Good afternoon or good morning, good evening, depending on in which time zone you are. Um, it's a long day for those who have been following multiple sessions, but for those that have just chimed in, welcome to the European Front session of today's special event organized by WYCJ and the Pacific Island Students Fighting Climate Change. My name is Mert Kumru. I'm the European Front coordinator, and today we have an amazing set of panelists that are going to um, be part of the session. I'll just give 1 minute to people to join. I see that people are still coming in, and then in a minute we're going to start. So grab a drink, take your time, and let's get this event going. Okie doke. I would like to ask my panelists to turn on their cameras so that people can see them as well. Uh, if that's possible. Amazing. Hi, Leah. Hi, Camilla. We have Safina. I'm hoping that Margareta's there as well. Amazing. And Joey, is it possible for you to turn on your camera too, or amazing? Yes. Um, I would love to ask my panelists to introduce themselves and tell everyone who they are. First of all, also great to see that we have an all-woman panel today for the European Front. That's something that we should celebrate and try to achieve more often. So I'd like to give the word to the one that's the first on my list, and that's Leah in the left corner. So Leah, if you could just briefly introduce yourself and tell everyone who you are, what you work for, and why you're involved, and in what way you're involved with the ICJO, that'll be amazing.
Sure. Thank you so much. And thanks so much for having me. Hi, everyone. My name is Leah. I'm a lawyer with client Earth, based in our fundamental rights team. And our involvement with the different advisory opinions, but specifically the ICJO, has also been that we have published legal analysis of the questions before the courts. Which you can find on our website, and we've been sort of involved in different ways in the different advisory opinions, depending on sort of the level of civil society engagement that's possible before the different courts and tribunals.
Amazing, thank you, Leah. Also, people might want to know this as well. Leah is amazing when it comes to on-the-spot impromptu video making. We saw that at the ITLAS advisory opinion when she helped me and Yula out. So she's also an amazing content creator, just so you know. Then I would love to give the floor to Margareta.
Hi, good day, everyone. I am Margaretha Weber-Inkesing. I teach international law at the University of Amsterdam. I'm also an adjunct law professor at the University of Fiji. And in the ICJ advisory proceedings, I represent the Republic of Vanuatu, as well as the Organization for African, Caribbean, and Pacific States. And it's wonderful to be with you today.
Amazing, thank you, Margareta. Then I would love to give the word to Camilla.
Hi, everyone. I'm Camilla Polgera, Program Associate at Ciel, part of the Climate and Energy Program. Ciel submit legal arguments to international courts on key topics through legal memos and support the state submissions and argument. I co-coordinate the Human Rights and Climate Change Working Group, cross-constituency advocacy space, bringing together civil societies and indigenous people, advocates, and experts from all over the world that seek to strengthen the recognition of the human rights dimension of climate change and to secure adequate legal remedies for those impacted. Thank you so much for the opportunity to speak on this topic and to be part of such an amazing panel.
Thank you so much, Camilla. And then Safina.
Hello, everyone. My name is Safina Okumu. I am with Greenpeace International as the communications lead for the Climate Justice and Liability Campaign. And how we're involved with the ICJ AO is that we did submit a brief and we're working with the communities to amplify these stories. And I'm so glad to be part of this panel. And thank you, Mert, and over to you.
Thank you so much, Safina. We have one more panelist that is coming in any minute now. Ida is now a listener in the audience, but she will join us shortly. So as soon as she becomes a panelist, we'll also introduce her briefly. Before we do that, I would love to also explain why we have this 12-hour global climate justice webinar today, because we're counting down the climate clock. We're here today for this European focus session, and it's a specific group of panelists, because today is a very special day. It marks the exact moment that the climate clock is ticking down, and that we have less than 5 years left to achieve a sustainable climate and achieve our goals that have been set out in the Paris Agreement. We, as a group of people, have all worked together to work tirelessly on the ICJ-AO, the ICJ Advisory Opinion on Human Rights and Climate Change, to make sure that states know what their obligations are and how we can achieve all of these goals. This group of panelists that we have today are from various backgrounds and have a very broad knowledge and know-how on getting several important stories and several important perspectives on how to achieve sustainable growth and sustainable development in not only the legal sense, but also in also through different ways, through an academic lens, through a youth lens, through a legal lens. There's several intersectional elements that we are going to discuss today in this panel. And I would also like to tell all of the attendees today that any questions are welcome, and any questions that are that there's always space for questions, so please write them down in the comments, and our team will then write them down, and then potentially could also ask you later to ask your question live towards one of the panelists. And I believe right now it's also very good to mention one more detail when it comes to the European perspective. It has been quite interesting to be a part of the European front for the past couple of years when it comes to the ICJ Advisory Opinion, since Europe is obviously historically responsible for most of the emissions when it comes to the advisory, when it comes to pollution and when it comes to climate change. However, being historically responsible also carries a burden for the future, which means we, as the European front, need to pressure governments into making sure that they uphold and are actively involved with the advisory opinion. We need them to be a part of the solution in the future, and going forward, we need them to be more proactively listening to what the demands are of the global south and what the demands of SIDS, so small island developing states, since they are right now on the front lines facing the brunt of the climate crisis already severely. Leading up to that, we are expecting that a lot of states will participate with the advisory opinion. However, having states representing the global north is also equally important, since they're the ones who need to also, for example, pay for the damages that have been done to the global south. So these discussions are all sort of intertwined in the importance of including both global north and global south countries at the same time, and making sure that the voices of those that are currently unheard are heard equally, or at least have an equal opportunity to be heard. That being said, I would love to now start with the interactive discussion with our panelists. And I think right now I would like to kick it off with Camilla. I think Camilla is the youngest panelist out of all. We're all, I mean, everybody's young, obviously. But Camilla, I would like to kick it off with you, because we're seeing a devastating climate impact in various parts of the world. And the climate crisis is not just something that is happening far away. It also happens very close here in our own backyard, so to say, in Europe. So my first question to you would be, how are we seeing that the crisis is slowly unfolding in Europe? And what does climate justice in particular mean to you?
Thank you for the question, Mert. So while I'm currently based in Geneva, I'm originally from Italy. Southern European countries, including Italy, are among the most critically affected by global warming in Europe. Italy is projected to experience some of the most intense heat waves, with a significant increase in frequency of extreme droughts, growing desertification, especially in the south. Italian cities have experienced severe flooding events in recent years. Not even a month ago, torrential rains caused devastation in France, Switzerland, and Italy, resulting in several fatalities. A year ago in Italy, floods in the Emilia-Romagna region caused 17 victims, left 20,000 people homeless, with more than 20 rivers bursting their banks, and 300 landslides engulfing more than 50 cities and towns. 6 months worth of rain fell in just 2 weeks, and Italy's beautiful landscapes turned into mud. Climate change is already having devastating effects in Italy and across Europe. States must act with the urgency and scale required to address this crisis. When it comes to solutions, there are not just the technical aspects and the carbon emissions reduction to take into account. Climate justice is an approach that centers on human rights and social justice. It means finding solutions to climate change while acknowledging and addressing the specific needs and vulnerabilities of those most impacted. As I mentioned, I co-coordinate the Human Rights and Climate Change Working Group, and every day this group reminds me what is at stake when it comes to climate justice. Children, youth, indigenous peoples, women, LGBTQI+ people, local communities, national minorities, people with disabilities, refugees, migrants, and other marginalized groups are not just anonymous entities. Their voices to be heard, their analysis is critical to achieving climate justice, and their lives and rights must be protected. Climate justice means handing over to future generations a world capable of sustaining life and upholding human rights. It means that countries, both most responsible for climate crisis and with the most available resources, must step up. The climate crisis is a human rights crisis, and states have an affirmative obligation to protect people from human rights harm and must address the varied human rights dimension of this crisis. Thanks.
Yeah, thank you, Camilla. And it's very interesting to also see and hear from your personal story too. And I feel like whenever somebody asks what climate justice means, it is like we have obviously like sort of a standard sentence that we utter as WYCJ, the Pacific Island Students Fighting Climate Change. But it's good to like understand what the concept of climate justice means for someone else, and also different dimensions, so to say, of climate justice. I do have one more question to add on further to that, Camilla, because I'm in a way still wondering, why does what is the importance of human rights when it comes to the climate justice approach when it comes to climate change, so to say? So like, what role does human rights play in that entire unfolding story, so to say?
So human rights are a tool that are necessary for the people most impacted by the adverse effects of climate change, to let their, as I was saying before, to let their stories and to let their voices and needs and vulnerabilities to be heard. States have obligations, and human rights and the human rights-based approach under which climate policies can actually deliver some outcomes that are necessary in this process.
Amazing. Thank you so much, Cami. I'm sorry, I'm calling you Cami, but it should be Camilla. Camilla, just automatic. I see that we have questions coming in from people. Amazing. I'm also asking the attendees to maybe address to whom the questions are aimed at, so we can then more easily ask questions to the panelists. So just for in the future. We're still waiting for Ida to join, so hopefully she's coming in a bit. But I'm also interested in the law scope of climate justice, and I would love to ask a question to Margareta about on this. I'm hoping Margareta is there. Amazing, perfect. Well, Margareta, it will be an understatement to say that you have been involved with the ICJO from the beginning. So I would love to also hear a bit more how you got into this entire advisory opinion and how you rolled in, so to say. And what would you say are the key legal issues at the heart of the advisory proceedings? And it would be very appreciated if we could get any insights on the manner in which, once the ICJAO is delivered, how the opinion will, for example, be read alongst the same lines as the Klimaserien case in Europe, or other very famous cases on climate change. So Margareta, the floor is yours.
Thanks, Bert, for these questions. I'll keep my answer to the first one very short. It could be it is a long story, but in a nutshell, I've been advising the Republic of Vanuatu on options to address the climate crisis through international law, and that exploration led to narrowing down of options. And then, of course, the group of students from the University of the South Pacific in around 2019 started a campaign focused on bringing the world's biggest problem before the world's highest court, and things started to move quite fast from there. And then, of course, last year, March, the General Assembly adopted a resolution requesting the opinion, and now proceedings are pending, and states are due to submit written comments by the 15th of August. So that is where we stand now. And in terms of legal issues that are at stake, there's of course a lot of nitty-gritty and detail, but very broadly speaking, I'd say there are probably three key issues. The first is that international law as it applies to climate change is not just about the climate change regime, UNFCCC, Kyoto, Paris, but it involves almost any area of international law that you can think of. And very importantly, that includes, as you already mentioned, human rights, but also, as the International Tribunal on the Law of the Sea confirmed in its recent advisory opinion on climate change, requested by the Commission of Small Island States on Climate Change and International Law, it also involves the law of the sea. And so that makes it very clear that climate change is not, that the climate change regime is not a lex specialis, as international lawyers would say, is not a type of law that then excludes the applicability of all other laws. It is an issue that can and must be dealt with under these various areas of international law. And then one of these areas also includes, of course, the general law of state responsibility. So that is a law that determines when the conduct of a state, the things that a state does or doesn't do, when that becomes a violation of international law, what conditions must be fulfilled to say that a certain norm of international law has been violated. And then also the legal consequences of what we then call a breach of international law or violation of human rights, or as per the law of state responsibility, an internationally wrongful act. And so it's important for the court to recognize that this law is applicable. And so violations can be established not just based on, for example, a state's failure to submit a climate plan, which states are obliged to do, indisputably so, under the Paris Agreement. That's clear. All states agree on that. So if a state fails to do that, it could be a violation of its obligations. But what is really important is for the court to establish that violations can also be established, for example, based on a state's failure to take adequate action to protect, let's say, people from climate harms that would violate their rights. And so here, the Klimasignorinen judgment provides a very important stepping stone, because the European Court of Human Rights has already following in a way, going first, but taking the same approach as the International Tribunal of the Sea, establishing that the climate change regime doesn't exclude other areas of international law that may also be applicable simultaneously, and so that includes then the European Convention of Human Rights. In this particular judgment on the Klimasignorinen case, the court also clarified when a violation of states' obligations under the European Convention of Human Rights occurs in the climate context. And so there's one paragraph in the judgment that in a way lays out what you can see as criteria, where you can see, oh, if a state fails to do these things, then it may be violating its obligations under the European Convention. So that is very important. And so we hope that the International Court of Justice builds on that. But what the International Court of Justice has been invited to do by the General Assembly in the questions that the UN General Assembly has first negotiated, agreed upon, and then put before the court, those questions ask the court to do more than what the European Court of Human Rights has done. And here, a really important aspect of that is the temporal scope of the question. So for the European Court of Human Rights, the question was forward-looking, was about what the state is going to do, could result in human rights violations in the future, and therefore the state is failing to prevent human rights harm, and that's unlawful. But what the courts here in this question is asked to do is to look not only forward, but also backward, and to consider also harm that has already been caused by past failures of states. And so basically going back all the way into the past, there's no kind of cutoff date. And so that's why states are now making arguments about the cutoff date, where some states are saying that, for example, when there was insufficient scientific knowledge to understand the risks involved in the burning of fossil fuels, etc., at that point, there would be no, let's say, due diligence obligations. That obligations would only arise when states started to understand these risks, and then arguments are raised that, oh, that is only in the 1980s or the 1990s, or some might go as far as suggesting that it's still all very uncertain. But in the submissions of many global South states, it's highlighted that actually awareness of the risks associated with burning fossil fuels started to emerge already in the late 19th century, and in the 1940s, 50s, there were pretty clear scientific papers already being published, and also within the awareness of states that suggested that these risks exist, and then arguments are made about due diligence, etc. And why is this so important? It's important because when a breach can be established also in the past, so going back into the past, that means that the international law then creates what we call secondary obligations under the law of state responsibility. So the unlawful conduct must stop. So if we establish that these excessive emissions at some point become unlawful, then that also it follows that this must stop. But in addition to that, international law then also provides that the states that have caused harm in this way have an obligation to make reparations for the injury caused. And that is, of course, the most important climate justice component of these proceedings. And so this question was not before the European Court of Human Rights. in any of the cases that it has decided on climate, but it is before the ICJ, and so that is, of course, also a very important global justice question. And for Europe, that means then having to grapple with some aspects of its past, which so far it has preferred probably to leave unaddressed to a large extent. So I'll stop here.
Yeah, I think that's the most diplomatic way you could formulate it, Margaretha, regarding to the European responsibility historically, but also amazing overview, I think, from a legal perspective, from a law perspective, what is at stake with this advisory opinion. I think all attendees that currently are not enrolled in a climate law course will probably join yours very soon. Who knows? Amazing indeed. And I see that Ida has joined us as well as a panelist. So glad to have Ida as well. I would love to ask Ida to maybe introduce yourself briefly, tell everybody where you're from and which organization you're representing today.
Hi, everyone. Sorry about the lateness. So my name is Ida, and I am an environmental activist and lawyer, and I represent Aurora, which is a youth-led organization, climate justice organization, suing the Swedish state for insufficient climate measures. So we're bringing a national human rights-based systemic climate case. And I'm also co-founder of Sweden's Environmental Association of Law, which is an organization of young lawyers and law students offering free legal counsel to environmental initiatives. And so the climate case is our largest case so far.
Amazing. I just love how casual people in this amazing panel that we have are saying, yeah, we're suing government X or government Y. It's just beautiful to see what kind of passion is living here. And Ida, I actually already also have a question for you straight away from the get-go. So do you think that litigation, whether international, regional, or local, in your case, for example, can play a role in securing climate justice and addressing the kinds of impacts we currently already see and experience? And to add to that, can it then make a difference in the day-to-day lives of people? So what kind of expectations should people have from these kind of litigations or these kind of cases, so to say?
Yeah, definitely. I want to start with an IPCC quote, which is sort of my favorite IPCC quote. And they're saying that climate litigation has the potential to be a powerful force in climate governance. So this global movement that climate litigation is, with both national and regional and international cases and initiatives, has the potential to do a lot, to make lots of important climate policy happen. And I think that this force for climate justice, climate litigation as a force for climate justice, acts in two main ways. The first main way being the legal way, because these litigation initiatives can lead to actual policy change through winning in courts, getting legally binding or clarifying decisions that people in power need to heed and need to take more drastic climate action. But a second way that climate litigation can act is through build and strengthen the climate justice movement, because litigation presents a powerful narrative. It's a compelling story. It's this David and Goliath dynamic of young people or vulnerable people bringing powerful actors before a court and holding them accountable. And that interest can be and is being harnessed to raise awareness and mobilize for the systems transformations required to mitigate the climate crisis. And these necessary large-scale economic, political, cultural systems transformations, or the even more disastrous climate change that is the alternative to these transformations, that inevitably make a concrete difference in the day-to-day lives of people. And so if climate litigation can help bring about these transformations and avoid the disastrous climate change consequences, which I imagine is the goal for most climate litigation cases, then litigation can help making the day-to-day lives of people less dangerous. So in clarifying rights and obligations, litigation can help end the business as usual, where governments and companies and other people in power can continue fueling the climate crisis. And depending on the remedies asked for in each case, then climate litigation has the potential to lead to mitigation and adaptation and reparations for loss and damage and climate finance measures. So litigation is a path to holding those who are responsible accountable and to try to make it impossible to get away with destabilizing the climate system and throw under the bus the people and ecosystems and plants and animals and communities who are most affected and often least responsible, as both Mert and Camilla has talked about. And from a European perspective, as was also mentioned, this is especially relevant because Europe's high emissions historically and now, and Europe's considerable technical and economic resources mean that we have a particularly large fair share, a particularly large responsibility to use our resources to take drastic climate measures. So European people in power need to be held accountable for their climate colonialism, basically. And the legal tools that we have for that requirement, climate crisis has to be met equitably, are largely found in the body of international law. And this is one of the reasons why I expect the ICJ-AO in particular to be so important, because if we can get a clarification on what points of international climate law means for the concrete obligations of states, then that can, depending on the outcome, of course, first of all, be very useful in national and regional climate cases against states like the one I'm bringing against Sweden. And of course, I hope that states will act in accordance with the AO anyway, without needing to be sued. Finally, I expect the movement around the ICJ-AO to do what it has already done and is doing, which is harness the story-driven power of litigation to raise awareness about the climate emergency and mobilize for climate justice across the globe.
Yeah, no, thank you so much, Ida. I think this is a very the way in which you explain it from Aurora's perspective, from your perspective, I think brings a great local scope to this, and also the implications of what litigation means for somebody's day-to-day ongoing business is very interesting, especially since the advisory opinion is not climate litigation. That's something that people still need to keep in the back of their heads. It's asking for advice from the international court and not suing anyone in particular, so to say. What the implications could be with an eventual progressive opinion, that's going to be seen in the near future. But it's very different to, for example, what you guys are doing right now in Sweden and what several other youth organizations are doing in other countries. So it's very good to have this notion and experience that you guys are bringing to the table for us in the future as well. Which brings me to Leah. I have a question for Leah as well, also a bit related to the law scope, because there are in fact 3 ongoing climate AOs right now, or proceedings going on. One of them has was recently finalized in International Tribunal of the Law of the Sea. But there's also one going on at the Inter-American Court. And I would love to hear from you, Leah, what are the connections amongst these 3 advisory opinion proceedings? And what would you say is the role of Europe and responsibility of Europe in relation to climate justice in the context of the other opinions as well? So in a way, I'm asking, where does the ICJ-AO fit into the entire story of all the proceedings? And also, what is the role of the European Union in all of these separate opinions? Over to you, Leah.
Sure, thanks so much. I'll also touch upon some of the legal themes. So there will be a little bit of overlap or repetition of what Margareta said, but I think it'll be quite helpful to understand all 3. I mean, I think sort of the first point is the timeline. So the connection amongst the 3 is that they were all announced within 4 months of one another. The ITLOS advisory opinion in December 2022, the Inter-American Court advisory opinion in January 2023, and then the UN General Assembly resolution requesting the ICJ advisory opinion in March 2023. So I find the timing or kind of the overlapping timing quite important. And then you just kind of mentioned it. It's also the choice of legal tools. So all these are, as you said, advisory opinions. So it's not contentious proceedings. So I think on the one hand, it shows that there's sort of a lack of clarity in the law, or sort of there's the wish to have some clarity in the law on how climate change and the effects of climate change and climate harms interact with states' obligations under these various international frameworks, agreements, conventions, and so on. And then I also think the one point I want to highlight that I think is significant is sort of the collaborative spirit all of these different advisory opinions. So if we look at the ITLOS advisory opinion, it's the Commission of Small Island States. So it's a number of, so the commission was originally founded by 2 small island states, and since then a number of other, or in the meantime, a number of other small island states joined, which sort of shows the collaborative spirit between small island states, considering that many of them are particularly affected by climate change. Looking at the Inter-American Court, that was a request by 2 states. So again, 2 states coming together to kind of address and tackle the issue of climate change. And then the ICJ advisory opinion, as Margareta has already emphasized, the student movement that led or that brought their request to a government, the government of Vanuatu, who then led a group of co-sponsors or core group of states that sort of supported the drafting process, that then eventually led to the adoption of that UN General Assembly resolution. And so I think that collaborative spirit of all these advisory opinions and the different processes is a really significant and important connection amongst those or across those 3 advisory opinions as well. And I think one of the things that also shows is that it's you see states, as states are involved in all these processes, advocating for a rules-based international legal order and kind of recognizing the significance of international law as it relates to climate change. And so now when we look at sort of the more legal side of it, there's an overlap in the themes and the issues that are being addressed. So Margareta already touched a little bit on sort of the applicable law question. And so ITLOS and the Inter-American Court are obviously specialized tribunals, so law of the sea and human rights, whereas the ICJ has a much broader scope, and the question before it is much broader, but there's an overlap in terms of, well, first of all, the applicable law, but also just in the questions themselves, that some of the themes that are being asked or some of the questions that are being asked sort of, look for clarification on similar questions. And then some of the legal the legal instruments mentioned in the question for the ICJ, it includes includes the Law of the Sea Convention, and it also includes a variety of international human rights instruments. And while the Inter-American Court oversees the American Convention, there is obviously significant overlap in the rights and freedoms guaranteed under the American Convention and the international human rights instruments that are being addressed by the ICJ. And so, yes, so if we look at applicable law, and as Margareta mentioned, which law is applicable to climate change, and with the Inter-American Court as I mentioned, it's a human rights tribunal, so clearly the question also seeks to understand, or the questions seek to understand how the human rights regime interacts with climate change and how those obligations under the human rights regime respond to climate harms and climate and the violations on human rights that arise or that are caused by climate change. And so I think, and then similarly with ITLOS, it was obviously a question also on how does the Law of the Sea Convention respond to climate change. And so we saw, or ITLOS, as you mentioned, issued its advisory opinion back in May. And so there are some really interesting findings there in relation to applicable law. Namely that ITLOS very clearly found that climate change, or that UNCLOS does respond to climate change and has something to say about climate change, and significantly also noted that it's the Paris Agreement, or the climate regime, is a separate legal regime to the Law of the Sea regime, meaning that there are separate legal obligations that arise under both. And therefore that what is required under UNCLOS, so the Law of the Sea Convention, might be different and may go beyond what is required under the Paris Agreement, because also the goals and the goals of those agreements are very different. With UNCLOS specifically, the goal being the protection of the marine environment. And so I think that was a very significant finding leading up to the ICJO, because it confirmed the applicability of other international legal regimes to climate change. And so with the proceedings before the ICJ, one of the issues being the applicable law, this obviously helpfully paves the way towards the ICJ. One of the other overlapping themes is the role of science. To what extent does science inform, or must science inform, policy making, legislative processes, decisions, so on and so forth. And again, we actually saw some helpful findings there in Klimaunion, but also in ITLOS, which confirmed that measures adopted by states have to be in line with the best available science. And in relation to climate change and ocean acidification, ITLOS considered the IPCC reports to represent the best available science. And interestingly, kind of looking at the objective assessment of state measures, so looking at, you know, objectively, did states comply with their obligations, yes or no? ITLOS also considered that the best available science is included in that assessment, meaning that a state's margin of appreciation is also, to an extent, limited by considerations of the best available science. Margareta kind of touched upon the point of the applicability of law of state responsibility, so I won't go any further into that, but the final point I mentioned, because that kind of ties into the second part of your question, is also the question of equity, common and differentiated responsibilities. This is obviously a term that common and differentiated responsibilities is a term that kind of emerged under the climate regime, and that has come up is a frequently or an important terminology in considerations on climate justice. And so the ITLOS advisory opinion, and the reason I keep on mentioning that advisory opinion is because we already have that advisory opinion, and so it kind of demonstrates those interlinkages quite well. So it confirms greater responsibility of those states with greater means and capabilities, nonetheless emphasizing that all states have or must take action. But so I think, and also, sorry, and additionally also provide assistance for developing states. And so I think this last part is particularly relevant when we speak about the roles and responsibilities of European states, because as you mentioned, greater historical responsibility, but also greater available means and capabilities, capacities to address climate change. And so I think the findings, and so I think the findings from the ICJ will therefore have sort of implications on how some of these legal themes and are meant to be understood and are then, you know, moving forward, meant to be kind of implemented across the globe. And I think I'll leave it at that for now.
Thank you so much, Leah. And I think it's also very good to now have a better understanding what role the other proceedings play in the broader scheme of things, so to say. And also especially since, for example, when people hear the Inter-American Court, what kind of implications does it have for the European front, or like what kind of implications does it have for different regions of the world? Well, they actually do have implications. And when it comes to the International Tribunal on the Law of the Sea, what if my state, for example, is not a signatory to the UNCLOS Convention? Does it still have any effect, or like does it still apply? I think all of those questions should be taken into consideration, taken into account, because all of these things matter in the long run in the way in which we're going forward with the advisory opinion as soon as we have it delivered as well. And this brings me to Safina, because Safina, I would love to ask you to look beyond the law and look ahead. And I think you have the Prometheus kind of look in the future and could help us in explaining that. So my question to you is, there's a narrative currently being shaped and a movement being built around the role of litigation. So how can we then leverage this momentum of the ICJ advisory opinion to build a stronger climate justice movement? And how can we make the issues at the heart of this case resonate more widely throughout the region, but also throughout the world, so to say? Over to you, Safina.
Thanks, Mert. Well, the thing is, we feel the importance of telling it like it really is. We tell the stories of people on the front lines, not just the smoothly polished presentations of wealthy states. Like, for example, the brief submitted to the ICJ by Greenpeace and allies, it tells the story through the eyes of 43 different individuals living in extremely vulnerable climate impacted situations. So there's the story from the Pacific Islanders, that is Fiji, Vanuatu, Solomon Islands, and so on. And we also have tied that in with the colony island of Bonaire in the Caribbean, as well as the Sami indigenous people in the Arctic, to the super polluted sacrifice zones in South Africa. And we also have a story of one of the first internally displaced communities in Mexico. They're called the El Bosque communities, and as well to the Klimasenia in Switzerland and in Norway, to the typhoon devastated parts of the Philippines. So this is to just highlight how it's best to tell the community's stories as they want it to be told. And this invites people in to have a look into what the experiences are. And the best people to tell this story are the communities who are living in these experiences on a daily. And with this, we aim to highlight that through like the climate justice angle, not all these cases have ever been confronted by a court, especially in local context. Especially, I'm based in Nairobi, Kenya, and we do have rainy seasons and like heavy rains and things, and there's displaced communities, but not many would take up the mantle to be like, okay, let's go to court. But you see, when an opportunity presents itself, like the ICJO, where people will feel, okay, so based on this advisory opinion, we have a case. And this is something that I think many communities are getting, should I say, the strength from? I don't want to use the word strength, but many communities are getting that the possibilities are endless feeling. And with the Klimasenia case, where they did specify, especially on associations and what an association means, and if you're disadvantaged in this climate harms, then you have leeway to take your case to a court of law. So I would say the ICJ also presents the opportunities to shape narratives for international law towards what justice will mean for the impacted communities and their different demands in the face of the climate crisis.
Thank you so much, Safina. I think that's very it's very intriguing, right? To see in what way this narrative is so important also. I feel like the creating a narrative and building this narrative also asks from us as civil society organizations and NGOs to be very much on the forefront of building this narrative and not letting it sort of be taken over by those that are not on the same page as us when it comes to how we should act with this advisory opinion. So I'm really compelled to like what you said regarding to how we should play a role in this and how we should be involved in this. And I feel like your NGO background also makes it more like the tad bit of activism that we need in this is also very important. Also allows us to be more concrete, so to say. So thank you so much, Safina, for saying that. I have a question for Leah, actually, and this is more regarding the state participation, because I'm wondering, Leah, why is the participation of states so crucial for this historic advisory opinion? And what are the risks, so to say, of a limited participation of states? And please then also make a sort of a distinction between the oral and the written proceedings, I would say.
Sure. So I think with the participation of states, it's so as we sort of have been discussing, so the an advisory opinion proceeding means that states are seeking clarity on certain legal questions, and so the option or the possibility for states to then submit their interpretations of the law to the court for the court to consider in its assessment means that if you only have certain types of states submit their legal arguments, you might only get sort of one interpretation of the law that might be sort of influenced by regional considerations, economic considerations, political considerations, so on and so forth. And so I think the broader the participation, the broader the views, and specifically for in my view, specifically for states that maybe haven't historically participated in proceedings before the ICJ for various reasons. Having their voice heard is a very important way to democratize the process, and just have kind of a diversity of voices being heard, and especially also kind of following up on what Safina just said, also getting sort of those voices from people on the front lines, and countries on the front lines, and so I think kind of having those perspectives play into these advisory proceedings is really, really crucial. And so your second part of the question was sort of the written versus oral part. So the written proceedings are in 2 stages. They tend to be much lengthier. Looking at the kind of, if we kind of look at the oral proceedings, those haven't been set yet, and I guess depending on the number of participants, we'll have to see how much kind of time is allocated to everyone. But the oral proceedings also offer an opportunity to include, I mean, as do the written proceedings, but oral proceedings also offer an opportunity to actually include firsthand testimony in the courtroom. And so I think, especially considering the impact of the climate crisis, and especially considering the human rights impacts of it, having those voices and having those stories in the courtroom is really, really important in providing sort of additional or emphasizing the legal arguments being made, because obviously there's human stories behind those legal arguments, and human stories that will be impacted by sort of the findings of the court. And so I think that's like an additional important element to consider for the oral proceedings as well.
Thank you, Leah. I would like to ask Ida to add to this, because Ida, we've just talked about the importance of state participation, but what do you think would be the potential awareness raising and mobilization role of the ICJ and the proceedings themselves? Where can the youth in particular play a role in this? And what kind of role do you envision for young people to play when it comes to like this awareness raising and mobilization creation role, so to say?
Yeah, so I think that there are many ways in which to use an initiative like this to build awareness and mobilize. So I think that just by asking the ICJ for this clarification, the movement behind the initiative is highlighting that the climate crisis is an emergency, that it's possible that the continued fueling of it is unlawful. And that in itself gives a platform to talk about the climate crisis, climate justice, climate transformations, etc. It gives young people media space. And that's like very basic. And then I think that also, as for the outcome of the proceedings, there is awareness raising and mobilization potential in both a favorable and an unfavorable outcome. And I think that this is true for most climate cases, including national ones. So if there's a favorable outcome, or from a local national litigation perspective, again, if you win in court, then you get a decision saying that states are acting unlawfully, that sufficient climate action is legally required, and states need to do more. So this can spur state action and civil mobilization to demand state action. But I also think that if there's an unfavorable outcome, if you lose in court nationally, then that sends a message that the current system of international law does not create obligations that are in line with what science says is very clear in saying that it's necessary to keep the climate system safe to live in. So this could maybe potentially have a wake-up call effect in saying that the current legal systems are not enough, and the current legal systems need to transform to be sufficient to deal with these multiple planetary emergencies that we are living in. And I think that specifically in relation to Europe, the awareness raising and mobilization effort is very important. As we've already talked about, Europe has the responsibility and the capability to to make it especially important to demand action from these states. The ICJ advisory opinion proceedings can specifically help put European emissions and European obligations in a global perspective, and highlight that like unless all states contribute their fair share of the global climate measures necessary to limit warming to 1.5 degrees, then the climate crisis will not be effectively mitigated, and European states has a large part of that. And also highlight that European states do not get to pat themselves on the shoulder about their climate policy being sufficiently ambitious, but they should carry a way larger part of the mitigation measures than they are currently even aspiring to. And as for the question about, sorry.
No, please go ahead.
No, as for the question about where youth in particular can play a role, I think that youth voices hold credibility in representing a group that will need to carry a disproportionately large part of the climate change effects that older generations are largely responsible for causing. And that makes us, together with vulnerable communities and marginalized groups and indigenous peoples, and also voices of the more than human world, the ecosystems and plants and animals, and many others, of course, youth are or will be an especially affected group. And as such, we should be especially listened to. And I think that youth movements have really shown that we are able to organize large and loud and skilled and healthy and internally sustainable and impactful movements. We're also good at being very clear with people in power and using a rhetoric or formulating ourselves in a way that are very does not take lightly on the science, but are clearly demanding things from people in power. And I think that the extraordinary efforts of World's Youth for Climate Justice and Pacific Island students fighting climate change and many others continue to show us that youth has a role to play in organizing these movements. And I also think that many youth movements, youth has something particular to contribute to the internal structure of climate movements, because I have found that many youth climate justice movements often live as we learn and put climate justice into practice in our internal structures. So working with intersectionality and prioritizing empathy and health and representation and sustainability and justice. So I think that youth has a role both on the front lines, speaking out, and organizing the movements that will do so together. Yeah,
no, thank you so much. And I think this brings me to another interesting point of view scope, and I'd like to ask Margareta to answer on this, because Margareta, how can something like the advisor opinion, once it's delivered, the ICJ advisor opinion, be utilized in a day-to-day work of climate legislation? And not only legislation, I mean, obviously from a European perspective, that will then mean how could the European Union and the European Commission, for example, make use of the advisor opinion, but also what could be then the potential influx of climate litigation in Europe and beyond? What is your idea on this, and what is your basically what's your hopes as well when we talk about this?
Yeah, that's a really great question. So when it comes to legislation, they're the forward-looking and the kind of more backward-looking or grappling with harm kind of elements to the opinion. And so when it comes to the first part, the forward-looking part, the opinion will essentially indicate benchmarks for states, so indicating that there's a certain minimum level of ambition that is required of all states, and so that states will need to look at their policies and legislation to essentially check whether what they are doing and planning to do meet the standards that the ICJ has indicated are applicable. And of course, equity is also critical here. So we hope that the ICJ will also provide some guidance there as to what how equity is to be operationalized in climate laws and policies. And then again, it's hoped that states will follow that and will not wait until they are sued for failing to do so. But of course, where there's reason to believe that a state hasn't met the standards that the ICJ has set, or its policies that planning or developing are not in line with that guidance, then of course there is room for litigation. And then of course every jurisdiction has its own way of dealing with international law. Sometimes it's very straightforward in some jurisdictions, sometimes lawyers need to be a little bit more creative to find ways to ensure that the courts attaches due weight to the views of the World Court. But in every jurisdiction there are options, and so that's how the ICJ opinion could also be brought to life. And then, of course, likewise, really for dealing with the impacts of climate change, harm that has already occurred. So that is an issue that many states are, to a significant extent, ignoring. Of course, states are taking action to adapt to climate change. Often insufficiently so, but still adaptation action is taken at the national level. There are funds, that money is being provided to developing states for adaptation. But as we all know, the scale is really nowhere near what it needs to be to adequately protect people against harm. And when it comes to loss and damage, that is even more so. And so it's hoped that the courts will provide this guidance that is ultimately going to lead up to a massive scaling up of resources and international cooperation to ensure that every state, and particularly those indicated in the question to the ICJ as being particularly vulnerable or otherwise injured or especially affected by the impacts of climate change, that those states really have the resources that they need to protect rights, but also restore rights where rights have been violated already to the greatest possible extent.
Thank you, Margareta. I would like to maybe add a little bit to this as well, Margareta. Since something that we've heard very often in the past couple of years when it comes to the ICJ advisory opinion is that this element of non-bindingness of an advisory opinion plays, well, in a way, a role. But I would love to ask you to maybe elaborate on the significance or maybe the insignificance of this element of non-bindingness. Could you maybe elaborate on that and explain to the audience what it means for us when we talk about a non-binding effect of an advisory opinion?
Yeah, thank you for raising that point, Matt. It's a very important one. I would argue that the term non-binding is almost misleading. So it is non-binding when you contrast it with the judgments of the ICJ in contentious cases, which clearly, as per the statute, bind the parties to the dispute. That is not the case for advisory opinions, and they are advisory, as the name indicates. Then again, what the court is doing in advisory opinions is clarifying existing law that is binding. And so in that sense, it helps to contrast the mandate of the ICJ when it comes to delivering advisory opinions with the mandate of a body such as the International Law Commission, which has a mandate to codify but also contribute to the progressive development of international law. So what the court is doing in advisory opinions is not developing the law or saying things about what the law should look like. It is telling the world what the law is. And the law is as binding as international law can be. And so when states do not do what the court indicates in its advisory opinion is required under international law, that state is violating international law, and then the legal consequences will arise under international law, and that will be also recognized by any credible judicial body in the world, whether it be a domestic court or a regional court or another international court. There is absolutely no question that what the International Court of Justice says is binding. And here it's sometimes helpful to look a little bit at history as well, because states have in the past, even in the recent past, sought to argue that they didn't necessarily need to do what the ICJ was telling them to do in an advisory opinion because the advisory opinion was not binding. Those states have been ultimately, I think, strongly encouraged by other states to change their mind and to ultimately take steps towards what you may call compliance with an advisory opinion. And so if necessary, follow up by, for example, the UN General Assembly is also very possible to ensure that states actually implement the opinion.
Yeah, thank you so much, Margareta. I think this is something very tangible that we can all now share with our peers and people we speak with that are a bit more critical of the advisory opinion. So we can explain to them in a more clear way what it means, what non-binding means, and that it actually is a very misleading term. So thank you so much for giving us that clear explanation. Before we go to a Q&A from the panelists, for the panelists, I would like to maybe ask all of our panelists to take the floor and to make one final reflection from their side, and that allows us then to continue into going into the Q&A mode, and then we open up the floor to all of our audience members to ask questions to any and all of the team. So I'd like to kick it off with Safina. Safina, what are your reflections? What is the final reflection that you have today?
Thanks. I think sitting here and listening to ourselves, one thing is jumping out at me. We need to also define how we want to define or shape the narrative. Like, whose narrative are we defining? You know, like the state's narrative, the social movement actors, the impacted communities. So that's one thing I think is the biggest takeaway for me in terms of describing this narrative, because it can have a limiting belief on what justice means for the community. So we really need to, also from a comms side, really try and have how we can describe justice, especially for the individual applications that it does apply to. And maybe at some point we'll get to where, you know, the community's demands inform this justice and what we are demanding from the courts. And yeah, and this can be translated into international law that can be binding, like we've just heard from Margareta. And so yeah, my takeaway will be, let's see how we define this narrative, because there's different narratives at play at any given time. Thank you, Matt.
Thank you so much, Safina. Then I'd like to ask Camilla for her reflection.
Sure. So it's already been mentioned here, but in Europe, we have a responsibility to address what is happening in our region and also far beyond. The lives and well-being of those on the front line of the climate crisis, wherever they may be, are inextricably linked with our own, and as is the well-being of future generations. This runs at the very heart of solidarity and of any approach that centers rights and justice. As Ida was saying, we are already seeing the mobilization of power of the ICJ advisory opinion even before it has been delivered, whether through youth-led events like this one and other broader ICJ advisory opinion campaign efforts or discussions that we are having within the Human Rights and Climate Change Working Group on climate reparations, and the potential role of the ICJ advisory opinion on this critical aspect of the climate fight.
Thank you so much, Camilla. Ida.
Yeah, I just want to say thank you to everyone who has spoken, and it always gives me, I become thankful to hear about the climate justice thoughts of different initiatives around the world, and it's going to be so exciting to see how these proceedings continue. Like a final reflection from me would be, in every time we talk about climate justice and about planetary justice in general, we're very good at talking about the intragenerational and the intergenerational human aspects of the justice, but I would want us to include the interspecies justice of climate, parts of climate justice and planetary justice as well. And in this context, the legal context and the question is about human rights and climate change, right? Because like rights of nature and rights of other species doesn't have a large role yet in international law. But I think it would be interesting to think in these perspectives when we discuss this type of planetary justice issues, because of course the most affected people are not just humans, but also communities of other species and other ecosystems.
Interspecies importance, yes. Thank you, Ida. Leah.
Sure, thank you so much. Final reflections, maybe just based on some of the topics that we've discussed, and also who's been sitting on the panel. I think it's the interdisciplinary approach, or maybe just that everyone has a role to play. There's obviously the student movements, there's the mobilization, there's the comms aspect, the narrative aspect, there's a community outreach, there's a legal aspect, but then also as we just heard from Margareta, there's also obviously the question of then implementation once there's an advisory opinion. So I think there's different roles to be filled, different roles to be played, different skill sets needed. And so I think that would be kind of my final reflection. Thanks.
Thank you so much. Then I would like to ask Margareta for her final reflections. And Margareta has to leave in 5 minutes. So yeah, Margareta, the floor is yours.
Thanks, Mert, and I'll really keep it to one sentence. So let me say, destroying the climate system may be unlawful under international law.
I think that sums it up. Yeah, that sums it up perfectly. It goes to show that we're very happy to have you, Margareta, on our side when it comes to this amazing case. Now the floor is open for all of the audience members to ask questions to our amazing panelists. So if there's anyone who has a question for Margareta, she needs to leave very quickly. So maybe if there's time for one quick question to Margareta, is it okay, Margareta, if there's one question for you? Perfect. Then now is your chance. Shoot your shot. And if there's any other questions, obviously, please take the floor now. So, are there any questions from the audience? I'm asking if my tech support is also seeing any questions. I think we have see a question. There's one interesting question from Anna Pickett, and Anna is looking to hear about reflections on how disability in particular is incorporated into the legal and justice-based analysis of state obligations, and especially when it comes to the climate adaptation and mitigation obligations. So to what extent will those implications be explicitly required to be accessible? Margareta, do you have anything to say on this?
Yeah, that's a really great question. Of course, yeah, I should flag that, and as you all know, the materials that have been submitted so far are strictly speaking confidential. So we can't say much about what has been argued so far, but there certainly is space for an intersectional analysis of impact and then the obligations of that on the several parts of international law. And here, those of you who are following the work of the court closely will have noticed the court's very recent advisory opinion on the question of the Palestinian, the occupation of the Palestinian territories that was handed down last Friday. And there it's worth reading closely Judge Hilary Charlesworth's declaration that she made, where she actually points out the importance of looking at discrimination from an intersectional point of view. And of course, that can and must indeed also be done when it comes to climate change. So, well, we all know the hearings will be in December. And so at that point, we would also expect the court to make public its written statements and written comments that have been submitted. And so at that point, there will be access to that. And I would then advise those of you who are interested to pay attention to what is being argued by entities such as the Organization for African, Caribbean and Pacific States, as well as the Melanesian Spearhead Group, as organizations that are concerned with the discriminatory dimensions of climate change.
Thank you so much, Margaretha. And I would also like to, from my point, thank you so much for being here today with us. So Margaretha, I know you need to leave, but we are super happy and super glad that within your busy schedule, you made the time to be part of this amazing 12-hour event, and especially for this European Fund session, because I know other friends would love to have you on board as well in their session. So we're glad to have you in our session. So thank you so much for being here today. And if anyone is interested in asking Margaretha any questions, I think you can email her always with ICJO related questions. And yeah, if there's anything that we can do from our side, please do let us know. But once again, from my side, thank you so much, Margaretha, for being here today.
Thank you so much, Mert, and thanks to everyone here really for your incredible leadership, for holding the torch, and for showing the clear vision that I think guides all of us. So thank you very much.
Thank you. For the rest of the panelists, there are some other questions that just came in as well, and allow me to read them out. So I have a question, and I think Camilla, this is a great question for you. It is, what is the difficulty of merging the climate science with legal heavy initiatives, especially considering the lack of the ICJ's dealings with climate science evidence? And I think this is it's a question for everyone. I'm not trying to put anyone on the spot here. So Leah or Ida or Safina, if you think this is a great question for me to answer as well. It's just open for everyone, but I thought maybe Camilla has some insights on this. But Camilla, if I put you under the bus, please do just ignore what I said. But to repeat the question is, what is the difficulty of merging climate science with legal heavy initiatives, especially considering the lack of the ICJ's dealings with climate science evidence? Leah, do you have something to say about this?
I'm so sorry, but I was actually just having an answer to the question on disability rights, and in that case, I'll just respond, sir. I'll just respond here now, just to point people towards a recent case or for the European Court of Human Rights, which has just given, I think, priority, which was just assigned priority, and this is a case that will consider the nexus of disability rights and climate change. There's some other kind of issues at play, but it will also take a look at disability rights. So I think that will hopefully be an important and interesting case to follow as well, Anna.
Yeah, no, that's very good. Thank you so much, Leah. Safina, Ida, do you want to answer to your question that related to the climate science?
I don't have any insight on the ICJ, but maybe from a national litigation perspective, I can answer, if that's okay.
Please.
Yeah. Okay, so we have found that climate science is absolutely integral for our case and our argumentation, because it is what clarifies the risks to human rights, right, and the impacts to human rights, and what also puts the entire case and the entire initiatives in perspective. But there can absolutely be difficulties in putting such a heavy weight on science. For example, it has led to accusations in like the media or the public debate that what we're doing is not bringing a legal case, but rather talking about politics in court. So I imagine that maybe that is something that's a similar problem that other cases face, that since this is so science heavy, then maybe that can lead to people viewing it as less legally. But just to highlight or underline that science is absolutely crucial for our case and for many other cases.
Thank you so much, Ida. Safina, you have your hand up?
Yes, I'd just like to reiterate what Leah had said earlier, that we all have different parts to play, and there's the part that science does play, and I believe it is important up to a certain extent, the same way we're bringing in communities' testimonials and things. So I believe science also does have a part to play.
Yeah, Thank you so much, Safina. That's a very good, very good point. I see that Camilla has her hand up. Please, Camilla.
Yes. Yeah, just to really briefly answer, this is a very complicated question, I would say. But of course, best available science should be an important factor in defining state's obligation, as held in Klimasignorinen and ITOS. Courts do not have to go deep into the science, but they can absolutely say that states need to take science into account when settling climate measures, as ITOS has done.
Yeah. Very great to have all various insights on this very difficult question, which is a very valid question as well. I could add one thing to this question. It might be good to look into a blog post that has been written by Dr. Niloufer Oral from the University of the National University of Singapore, and they are exactly talking and discussing about how the court should deal with evidence when it comes to a climate change advisory opinion, and the role of Article 50 of the ICJ statute, which basically deals with allowing experts and witnesses to be involved in advisory proceedings. So I would highly recommend to those that are asking these questions to check Dr. Niloufer Oral from the University of Singapore, National University of Singapore, Article 50 blog post. It's a very good one, and it explains in a nutshell what the role is of evidence. There's one more question in the audience, and that's the question related to science. And the question is, do you think science should be the biggest factor which we use in determining law on climate change? And that's an interesting question. So what should the role be of science? Safina, Ida, Leah, and Camilla, what do we think?
I'm happy to comment first. I mean, I do think science has an important role to play, but definitely not the only one. And I think it's just one of multiple elements that play into assessment, or should play into sort of assessments and determinations on the law of climate change. Obviously, science can't capture elements of, or it can at times, but not always, capture elements of justice, of equity, of different considerations. And so I think while it is one important element, it is definitely not the only one. And so I also think, and we have sort of seen that, we saw that in the proceedings before ITLOS, and this is also something that we have picked on in sort of our analysis of the questions before the ICJ, is that while the IPCC obviously represents very thorough scientific analysis and very, it is a process that summarizes and sort of evaluates the level of scientific consent, meaning that it sort of summarizes, scientific findings of the previous years, and it doesn't conduct sort of experiments or assessments of its own. And so what does that mean? It means that by the time that the IPCC reports come out, sometimes the scientific findings that they're based on are already several years old. We actually saw the Commission of Small Island States also raise that argument in the ITLOS advisory proceedings. And so why I'm in no shape or form trying to undermine the scientific basis. All I'm trying to say is that there's other elements that are important beyond the science and that need to be considered and that play into determining sort of legal context and legal content.
Thank you, Leah. Does anyone want to add to what Leah has said? Then, looking at the time, it is 1 minute before we're going to end our session. And that brings me to the final remark from anyone that still wants to share something. Now is your chance. So if anyone from the audience still has something burning on their lips, now is a final chance. And it's also good to mention that all of these amazing panelists that we have here today are also, you can also reach out to them and their organizations through email or Instagram. I think email might be a bit easier. So do reach out to WYCJ or the PIS FCC, and we can then connect you with the panelists and help you forward. I would like to thank Leah, Camilla, Safina, and Ida for putting their amazing time in favor of this event, of this 12-hour important event today, and also Margareta as well, to be here today to help explain and teach us a bit more in what ways we can all engage in active advisory opinion, and how we can use this in the future, and how we can make sure that the climate crisis is not anything that's not something that we just passively are accepting. No, it will be something that we're actively changing for the better, changing for the good. I'm super happy and super excited to invite you all as soon as possible to The Hague, as soon as the court is going to entertain the oral hearing. So please be welcome. We will host you as much as possible, and we can't wait to celebrate a great, progressive, wonderful advisory opinion. I would also like to thank from my seat over here all of the amazing technical staff. Before we end, I would like to give The Hague Mobilization Coordinator, Jasmine, final word, because she has a message for you all. Over to you, Jasmine.
Hi, everyone. Thank you, Mert, and also thank you again to all the wonderful panelists. I'm learning a lot, so definitely really appreciate it. So my name is Yasmin. I'm the Hague Mobilization Coordinator, part of WYCJ, and I'm just here to talk to you briefly about the Hague Mobilization Task Force. So as discussed in this panel as well, the ICJO presents an important opportunity to strengthen the climate movement, but this also works vice versa. It is very important to organize and mobilize around the advisory opinion as well to pressure states and also the court to encourage a progressive AO. So I'll keep it very brief because we don't have a lot of time, but the task force essentially is a group of organizations, civil society and law, etc., where we can work together and coordinate our actions around the oral hearings that will be happening in The Hague soon. The group is dedicated to organizing and coordinating impactful events and planning around the orals and the hearings, the orals and therefore the hearings. So if you are part of an organization looking to get involved, we'd love to invite you. You can contact me, but we'll also send around our email addresses, etc. But my email address is yasmin@wy4cj.org, so super easy. And then if you're an individual looking to get involved and not part of an organization, you can also sign up and help. We're definitely looking for a lot of volunteers for our events. So we do also have a sign up for new campaigners. Yeah, if you sign up to the link both on our website, but we'll also share this, you can indicate your interest in volunteering for our mobilization actions during the orals. So love to see many of you there. And thank you for your time, and let me know if you have any questions.
I couldn't have not said that any better. Thank you so much, Yasmin. And thank you so much for everybody to be here today. And if you're interested in following other sessions of the 12-hour WYCJ global event, then please check our Instagram. And thank you so much for being here. Have a great day all. Bye-bye.
Bye, thank you.